So what if you are considering completing an estate plan for yourself, or for a parent or parents for that matter? What are some of the things that you should consider prior to meeting with an estate planning attorney? Because eventually you're going to need an estate planning attorney. Initially, you want to think about your family dynamics. If there are factions of your family that don't particularly get along, then you may want to think about how you're going to address that in your estate plan if this is for you. If you are helping your parents with an estate plan, then it might not be a bad idea to video them expressing their wishes or potentially receiving a letter of competency from a primary care physician prior to starting up the estate plan process. Now you might say, well, why would you need a letter of competency? Well, oftentimes what happens with challenges in any estate, the first type of a challenge has to do with competency and whether the person was under duress. So you want to try to address that issue if you can. Next, you want to consider summarizing assets that will be involved in the estate, whether it's for yourself or for your parents. Assets meaning real estate. It could be bank accounts, money markets, CDs, IRAs, 401ks. It could be other types of investment stock. In any event, life insurance policies. In any event, what you want to do is summarize those items. And as I've explained in the past, in past videos, which you'll see the links to below if you're watching YouTube, or if you're watching Facebook, the links will be in the description above. When you're considering the valuation of a person's estate, it is composed of both probate and non-probate assets. Probate assets are items like real estate or bank accounts that may not be titled with somebody else, where there's no right of survivorship, where there's nobody else on title with that individual, whether it's for you or for your parents, and there's no right of survivorship. Or it could be like a bank account where there's no beneficiary listed. That would be something that would have to pass through the probate court, because when the person passes away, if that asset is in their name individually, a judge would need to make a determination on that. Now, when I'm talking about non-probate assets, those can be assets that are held jointly with a right of survivorship with somebody else. So in other words, if you pass away, or if one of your parents passes away, somebody else is on title and they hold it jointly with the right of survivorship, and so therefore they would receive that beneficial interest of the individual that passed away. So in other words, the surviving title holder would receive that title interest. The asset also could be one that has a beneficiary on it. And when that does happen, when a person passes away, no judge is necessary. The asset will flow to the beneficiary. Sometimes on bank accounts, they can be held jointly, or there can be a pay on death or transfer on death option. Once again, no probate necessary, no judge necessary on that type of an asset. So those assets would be non-probate. Both types of assets go into the valuation, the overall valuation of a person's estate. So now, why is it necessary to summarize assets and to try to get evaluations on each of the assets involved in a person's estate? Well, a good estate planning attorney is going to look for issues, whether there are estate taxes or potential capital gains taxes down the line. A good estate planning attorney is going to be able to advise you about those things. Now, some states don't have an estate tax, but states like Massachusetts, where I'm from, there is a $1 million estate tax exemption. And so that means that if a person's estate runs over $1 million, then the state will tax that estate at the time of the person's passing, and the family or the estate will have to pay the taxes to the state of Massachusetts. When it comes to capital gains, it's always good to know whether there's any potential exposure to you down the line or to your family members down the line with a particular asset. Typically, when an asset is probated through the probate court or received through some type of a inter vivos trust, there is a step up in the basis at the time of the person's passing. And what that means basically is the recipients, the heirs of the estate, will receive a step up or an increase in the valuation of that asset. So if they sell it down the line, there's a very small capital gain or no capital gain at all. So once you have considered all of the initial issues and summarized the assets of your estate or your parents' estate, then it might be time to reach out to a seasoned estate planning attorney to actually have a meeting and discuss what the potential issues are. Now, if you're watching me on Facebook, make sure that you like the video. If you're watching me on YouTube, make sure that you subscribe in the lower right-hand corner. And some of my prior videos will be appearing here. Make sure that you check those out along with the list of related videos. Dave Ceruolo, CeruoloLaw.com.